Hi, everyone. Thank you for joining us today for the newest installment of the Student Loan Webinar Series. We have a lot of folks registered, so I want to make sure they all have a chance to jump on and log in. So let's give everyone just one more minute and then we will be back momentarily. Thank you. Okay, let's go ahead and get started. Thank you for your patience. Again, thank you for joining us today for some student loan updates. My name is Katie Carresco, and I'm a targeted outreach specialist for the Department of Financial Protection and Innovation, which we will shorten to the DFPI. So slide, please. Before we get started and hearing from today's speaker, I have some important information to you about today's webinar. Throughout the entire webinar, your video, microphone, and chat will be turned off. So since this event is being recorded, it will be available to you on DFPI's YouTube channel, which I'll refer to a little bit later and give you that direct link. And it will be emailed to you along with all of these slides, so don't feel like you have to write everything down. It will be emailed to you probably later today or even tomorrow at the latest. If you have any questions during the webinar, please add them to the Q&A function. You're welcome to do that at any time. And if your question isn't answered by our team of experts right away, we'll try our best to get to it live during the Q&A session towards the end. You can also save your question until that time as well. So now I'm happy to introduce today's speaker, Celina Damian, the DFPI Student Loan Ombudsperson. Celina, please take it away.
Thank you, Katie. Hello, everyone. Thank you for joining us today. I know this is a busy week for everyone, or slow week in some cases, but thank you for joining us for our last webinar of the year. We are excited about everything that's going on in the student loan landscape and some great updates for 2023. So thank you for joining us again. Once again, we are the DFPI. We are California's Consumer Protection Agency. In 2020, under the California Consumer Financial Protection Law, we were given expanded authority to oversee previously unregulated providers of financial services, including debt collectors, debt relief companies, credit reporting agencies, consumer credit report companies, and student loan servicers. As such, we accept and investigate consumer complaints. We take legal action when companies are not in compliance, and we conduct education and outreach, such as this one, to enhance consumer awareness and protect consumers from fraud and abuse. Next, please. With more than 4 million Californians owing $156 billion in student loan debt, it was imperative that California created additional protections for borrowers. One important protection, in addition to the federal protections for borrowers, is the California Student Borrower Bill of Rights, which was introduced in 2020 as Assembly Bill 376. It became effective January 1st of 2021, and it applies to student loan servicers doing business in California, including state licensed servicers, as well as banks doing servicing, and it applies to borrowers with both federal and private loans. California is only one of 13 states that has established advanced legislation such as this one to strengthen oversight of student loan servicers and protect borrowers. And just briefly to remind everyone, the difference between the servicer and the lender. The servicer is the company that is the borrower's main point of contact. The servicer is the company that is answering direct borrower questions, are the ones that are processing payments, the company that is helping borrowers with repayment plans with their options, different than the lenders who are the ones who actually lend the money and set the terms. So for federal loans, your lender is Department of Education, and the servicer are those that contract with Department of Education. It's going to be Mohila, Advantage, Great Lakes, Navient, companies such as those. And what does the Borrower Bill of Rights do for borrowers? It prohibits servicers from engaging in abusive, unfair, or deceptive practices. It requires that they work in the best interest of borrowers and provide accurate information. That's information about repayment plans, about forgiveness plans, and steer them in the right direction and help them pay down their balances. It establishes special protections for military borrowers, borrowers working in public service, older borrowers, and borrowers with disabilities. They have to provide specialized training for staff to assist those borrowers. It established my position, and I work directly with borrowers to help them understand their rights and their options. And DFPI will accept complaints if a servicer is not in compliance, if they have acted unlawfully, and a servicer must respond within 15 days. Next, please. Okay, the first update, and one that has been in place, really something that has been going on for a while. Many of you may have been part of this, but under the CARES Act, federal student loan payments were paused and interest rates were set to 0% for eligible federal loans. This became effective March 2020, and it applies to borrowers with direct loans or loans that are owned by the Department of Education. Under the CARES Act and during the payment pause, servicers were required to report to credit reporting agencies as if regularly scheduled payments were occurring, and they are reporting monthly payments of $0. Delinquency is not being reported during the payment pause. Next, please. In response to the courts blocking the recent Biden debt relief program that was announced, the 8th student loan repayment extension was announced. As of now, payments are due to resume 60 days after the department is permitted to implement the program, the Biden relief program, the cancellation program, or when the litigation is resolved. If the program has not been implemented and the litigation has not been resolved by June 30th of 2023, payments will resume 60 days after that, or September 1st of 2023. So as of this date, as of today, there is not a set date for payments to resume. What borrowers can do now is just make sure that they update their contact information with their loan servicer and on studentaid.gov. Make sure they know who their servicer is, since there were a lot of transfers that occurred during the payment pause. And they can also go to the loan simulator that FSA has on their page to find a repayment plan that meets their needs. There may have been a change in family size, change of employment, change of income during the payment pause. So it's important for borrowers to be prepared for the restart of payment and when they have to resume making those payments. Next, please. Something else that is it's actually already taking place, and it's very important for borrowers, is a one-time account adjustment. In addition to the public service loan forgiveness, there is a lesser known forgiveness program. It's the income-driven repayment forgiveness plan. Under the IDR forgiveness, a borrower who has been making payments for 20 to 25 years on their federal loans can receive forgiveness of the balance of their loans after making payments for that period of time. Currently, there is a one-time account adjustment that is taking place where borrowers will receive credit towards both IDR and PSLF forgiveness for any months in which borrowers made payments, regardless of payment plan, as long as they were making payments. They will receive payment credit for 12 or more months of consecutive forbearance or 36 or more months of cumulative forbearance. They will also receive credit for months spent in deferment prior to 2013. And any borrower with loans that have accumulated time in repayment of at least 20 or 25 years will see automatic forgiveness, even if they are not currently on an IDR plan. PSLF applicants will see an increase in their qualifying payments, and these changes will be applied automatically. The only borrowers that will have to take action are those that have FFEL loans. Similar to the PSLF waiver, borrowers with those commercially held FFEL loans will have to consolidate into direct loans prior to May 1st, 2023. The first round of, or the first adjustment took place in November, and the next adjustment will take place in July to give borrowers a chance to consolidate their loans and do whatever else they need to do. But for the borrowers with FFEL loans, they do have to consolidate their loans. FSA estimates that these changes will result in immediate debt cancellation for at least 40,000 borrowers under PSLF, and several thousand borrowers with older loans will also receive forgiveness through this program. And I think this program will benefit those borrowers the most. So I hear from borrowers all the time that have just been paying. They still have a balance on their loans. This adjustment will help them, but most likely those borrowers also have the older FFEL loans. So it is going to be important that they take action and consolidate. More than 3.6 million borrowers will also receive at least 3 years of additional credit towards IDR forgiveness. Next, please. Now on to the student debt relief, which I mentioned earlier. On August 24th of this year, the Department of Education announced up to $20,000 in loan cancellation for borrowers with federal loans who were Pell Grant recipients, and $10,000 for non-Pell Grant recipients. Borrowers were eligible if they met certain income requirements and they applied for the relief. The application went live on October 11th, 2022. However, lawsuits were immediately filed against the program and against the administration. And in November, a federal judge and appeals court blocked the program. The Biden administration immediately appealed, and they maintain that they have the authority to provide this relief under the HEROES Act. Just last week, the Supreme Court set out a schedule for next step, and oral arguments are scheduled for February 28th of 2023. In the meantime, the Department of Education is no longer accepting applications, and this is the message that borrowers will see when they go onto that page. 26 million applications were submitted, and 16 million were already processed and approved prior to the court issuing or blocking the program. Next, please. What should borrowers do in the meantime? If they've already applied, they should have received a confirmation email immediately after submitting the application. The department will keep the applications on file during the litigation. And unless a borrower hears from Department of Ed requesting further information, at this point, they do not need to do anything. Again, just make sure that the borrower's information is up to date, and then make sure they have updated emails, as they will be receiving emails further down the line. If borrowers have not yet applied, they can just confirm their income eligibility and Pell Grant status. If the application goes live again, or when the application goes live again, they'll just be able to apply. Yeah, and again, just make sure you have the right type of loan. Public service loan forgiveness. There was a lot going on with this program this year. PSLF is a program that was created in 2007 to encourage individuals to enter and remain in public service. Under the program, student loan forgiveness is granted after satisfying certain criteria for 10 years. The requirements are that a borrower has to have the right type of loan, They have to be on the right type of repayment plan, have the right type of employment, and make the right number of qualifying payments. Next, please. The PSLF requirements, now we'll go over them. The borrower must have federal loans. A borrower must have direct loans. They can be subsidized or unsubsidized. A borrower can have direct plus loans. Those are the graduate plus loans or the parent plus loans. However, if a borrower does have parent plus loans, they must consolidate into a direct loan and then enroll in an income-driven repayment plan. One thing to note for the parent plus loans is that when they do consolidate, their account gets reset to 0. So they will have to start on the 120 from 0. A borrower must also be paying under the correct repayment plan. That is an income-driven repayment plan, which is the best option for PSLF. Then qualifying employment, which is one of the most important requirements. A borrower must be employed by a government organization. It can be at any level: federal, state, county, city, municipal, tribal, and military service also count as qualifying employer. A borrower can be employed by a 501c3 organization. That's a nonprofit organization. A borrower must be working full-time or 30 hours, and they can be in any position. So it doesn't matter if they're in clerical, maintenance, research, legal, as long as their employer is a qualifying employer, they qualify for PSLF. And then a borrower also has to make the right number of qualifying payments, which is 120 payments. These payments do not have to be consecutive. Therefore, if a borrower leaves for private service or has to take time off for other reasons, they can come back, continue certifying employment, and continue on their PSLF track. A borrower can prepay or make lump sum payments for up to 12 months, or when the next IDR certification is due. As long as they qualify employment for that period, those months will be qualifying. Next, please. This is the PSLF application. Just very important on this, to make sure that it does require an employer's wet signature, which is an actual drawn signature. It's very simple. A borrower can submit a paper application, or they can use the PSLF help tool on the studentaid.gov page, and they can generate this application, pre-fill it out, download it, and then submit it to have the employer sign it, and then submit it to the PSLF servicer, which is MOHELA. Just make sure that the dates are clear, that it's legible. You want to avoid any delays or denial. But as you can see, it's 2 pages, very simple. If you are not sure whether or not you are at your 120, you can just fill out box in section 2, boxes 2 or 3. It doesn't matter. They will get checked either way for the 120. So that shouldn't be an issue or delay the application. But this is what the PSLF form looks like. If you have more than one employer, you will need more than one application. Next, please. PSLF waiver and beyond. Many of you may have heard about the PSLF waiver, which ended on October 31st of this year. The PSLF waiver was created to fix some of the issues with PSLF. It was a 1-year program or 1-year waiver where it suspended some of those traditional requirements that I just went over, and it allowed borrowers to apply for PSLF and qualify where they would have not been able to otherwise qualify. MOHELA and Department of Ed is they are still processing the applications and the consolidations because there were so many and the huge backlog. These things may not be happening in the same order as they typically happen. Usually it takes about 90 days for both the consolidation and that PSLF application to be processed. Right now, these are still being processed. MOHELA has even hired contractors to help them process these. So if a borrower consolidated and submitted even in August, September, closer to October, you will be probably waiting until 2023 to get, well, that's in 2 weeks. You'll probably be waiting still a bit longer for an answer, but just be patient on these. There's still many that need to be processed. And they already, Department of Ed already started making the automatic IDR adjustments, which I spoke about earlier, which will affect and increase the PSLF count for borrowers as well. So there's just a lot going on. So just, I ask for patience. There is a reconsideration process that FSA has, similar to an appeal process for applications that are denied or that the decision is incorrect or borrower feels that it's incorrect. There is a reconsideration process that is in place for borrowers who are not getting the forgiveness. California borrowers have already received 1.2 billion in PSLF, and in total, 825,000 Californians qualify to have their debts eventually canceled through PSLF. So this is a very important beneficial program for borrowers. Not everyone has applied though, so it's good to get the word out on this program. Next, please. And then some important PSLF changes that are coming in 2023. I'm going to go through these. Some of these have to do with employment certifications and some with the program overall, but these changes are expected to take place or will take place July 1st. And some of these provisions they're already using, so just really important for everyone to know. Now, as far as payments, under PSLF, now borrowers will be able to obtain credit for late, partial, or lump sum payments if the borrower certifies the employment. Prior rules only counted a payment as eligible if the payment was made in full and within 15 days of the due date. Now, they will also count certain periods in deferment or forbearance towards PSLF, including cancer, military, post-active duty, student deferment, where these periods previously did not count. One very important rule or change: when consolidating, borrowers will receive a weighted average of existing qualifying payments towards PSLF instead of resetting the count. So under current rules, borrowers will lose all progress toward forgiveness when they consolidate. Under the new regulations, for example, if a borrower with 60 qualifying payments on direct loan with a balance of 30,000 who consolidates their loan with another direct loan with a balance of 30,000 with 0 qualifying payments, won't have a new payment count of 30 payments. So they will not have to start at 0 months again, or 0 payments. So again, this is going to be for like the FEL borrowers that have to consolidate, those that have the older loans and now they're consolidating with the direct loans. So if they weren't able to take advantage of the PSLF waiver, it's similar to that. They don't get the full benefit, but they're not losing or resetting the count, which is really, really important. Next, please. The department will also adopt a single standard of full-time employment at 30 hours a week. Prior rules required borrowers to either work 30 hours per week at multiple jobs or whatever their employer defined as full-time, which created a lot of confusion for not just the borrowers, but the employers when filling out the forms. The single 30-hour-a-week requirement will make it easier for borrowers and employers to establish what it means to be full-time. It will also allow a qualifying, I'm sorry, I skipped one. It will also require employers to give adjunct and contingent faculty credit of at least 3.3 hours of work for every credit hour taught. Historically, employers have struggled to determine the work hours of adjunct instructors, and a lot of them would just not even apply. So this new calculation will help employers and borrowers figure out how to certify the hours for their PSLF. It will also allow a qualifying employer to certify employment for a contractor in certain situations. So this is for example, a doctor that is providing services at a nonprofit hospital. There are some states like California and Texas that prohibit direct employment of these doctors. Therefore, the hospital will be able to certify employment for that borrower, and therefore them being able to qualify for PSLF. It will also codify the reconsideration process for borrowers to have their applications reviewed again. If there are errors made in the review, borrowers will have basically a second chance to look at for the reconsideration if there is a denial. Next, please. And then the Fresh Start program. The Fresh Start program is a program that will help 7.5 million borrowers with defaulted federal student loans receive a fresh start by eliminating the impact of delinquency and default. The loans that will be eligible for a Fresh Start are any defaulted direct and FFEL loans or Perkins loans, defaulted Perkins loans held by the U.S. Department of Education. The program will last for a period of 1 year from the end of the repayment pause. And since right now we don't have a set date, this is just something to keep an eye out. Some of the benefits have already started taking place though. Under the Fresh Start program, borrowers will be taken out of default when they opt into the program. They'll have access to IDR plans. They will regain access to Title IV federal student aid. They will not be subject to any collection efforts or collection fees, and they will be eligible to rehabilitate their defaulted federal student loan if they rehabilitated during the payment pause. Next, please. Some of the credit reporting features of this program is that it will delete delinquent loans from credit report after 7 years. It will report all other defaulted loans as current and not in collection status. It will use a loan's original date of delinquency if a borrower becomes delinquent or goes into default again. So it will not reset the borrower's 7-year timeline on their credit report. As of July 10th, Ed already removed any default notations from the federal Waiver system. And Department of Education will reach out to borrowers with information about what action to take. Next, please. Now I will talk about borrower defense discharge and some updates regarding this program. So borrower defense discharge is a program that allows federal borrowers or borrowers with federal student loans to seek cancellation of their loans if the institution engaged in certain misconduct. This is usually going to be those for-profit schools or institutions. 2022 was a historic year, and Ed approved or discharged a historic amount of loans for borrowers. To date, Ed has already approved $38 billion in discharge for 1.7 million borrowers who were defrauded by their schools. One of the important, really important cases or updates is regarding the Sweet versus Cardona case. This was a class action lawsuit that was filed by borrowers back in June of 2019. They filed against the Department of Education because they failed to decide on their applications or for unfairly denying the applications. The final settlement agreement for this case was approved on November 16th of this year. And for the 264,000 borrowers that attended one of the 151 schools under this lawsuit and that were part of the class settlement, they will automatically see their federal student loans canceled. They will also receive refund of any amounts paid, and they will see a repair to their credit reports. So for those in this group that were part of the settlement, they will see relief within the next 12 months. There were additional terms in this lawsuit or in the agreement for those who weren't part of the initial settlement, and for those who applied for borrower defense discharge after, and as well as for those who apply in the coming months. Really important update on this case. There are also new changes coming to borrower defense overall, which will help borrowers in the future as well. Next, please. And then just some other just critically important changes that are going on or updates. The department has released updated guidelines regarding bankruptcy. It will make it easier for borrowers to discharge student loans in bankruptcy. Under current guidelines, it's almost impossible for borrowers to receive bankruptcy. The Department of Education makes it very difficult. They will basically fight a borrower in court until a borrower gives up. And there's only been very few discharges under the new guidelines. If a federal student loan borrower can prove that they're experiencing distress, the agency will now recommend that a bankruptcy judge discharges a borrower's student debt if the case warrants it. I wouldn't recommend going out and immediately filing for bankruptcy, but this is really a significant change, a significant just update, and very beneficial. We want to see how everything is rolled out. Don't go out and file bankruptcy yet, but this is going to give those borrowers that are in distress, that really need their student loans discharged. This will just give them that opportunity. And Department of Education has already stated they will not, these are the new guidelines regarding bankruptcy. Other regulations that will go into effect July of 2023. They are streamlining the application process for the borrower defense discharge program that I spoke about, total permanent disability discharge, which is for borrowers that are on total and permanent disability and can no longer work, and then closed discharge for those borrowers whose school closes when they are enrolled in the school. It will limit the amount of interest accrual through interest capitalization. Interest capitalization is when interest that has not yet been paid is added to the borrower's principal balance, therefore increasing the borrower's total account balance. This is really what has caused these balances to balloon over the years. So they will eliminate certain capitalization events, including when a borrower first enters repayment, when they exit forbearance, when they leave an IDR plan. And then this is great for interest. And then they will be making some improvements to income-driven repayment plans and establishing additional borrower protections, which we will keep everyone posted about next year, but just things to be on the lookout for. Next. And now I will pass it over to Katie because I am completely losing my voice, but thank you everyone, and I'm still here for the Q&A.
Thank you, Celina. Yeah, unfortunately, there are always people trying to take advantage of situations. So we want you to beware of these scams, especially when somebody or a company individual contacts you to solicit some sort of personal information from you. And this could be from the phone, email, and mail. Just remember to please keep all of that information to yourself. Unless you've reached out to them first. I'll just read some of these bullets. There's nothing that a company can do for you that you can't already do on your own for free. Loan servicers and the federal government, we do not call people out of the blue. As a state government worker, we just don't do that unless you're already expecting something from us. Always verify the information and research the company, get Google out and be proactive about it. Look them up before you give anybody any information. Never give out your login and password information. That's really important, basically, when you're doing anything online. Don't subscribe to any monthly services offering help. You just don't need that. You could probably do all of that stuff for free. And again, always file a complaint if you've been a victim of fraud, or even if you think that you've been a victim of fraud, let us know about it. Next, please. So the most popular types of student loan scams that we're seeing that we want you to know about. Let's see. Consolidation scams. When somebody contacts you saying that they can consolidate everything for you, be really wary of that. Student debt relief or elimination scams. Be careful with that one too. Identity theft. Again, don't give out any personal information. Even if you think it's not important, you'd be surprised what people can do with just a little bit of your information. Advanced fee scams. You never want to pay anybody up front for anything. And law firm lawsuit scams, when you get an email, especially, or a letter in the mail, it may look legitimate, that's saying that you could be part of a class action suit. But again, it's probably just a scam. Again, you can find out more about all potential scams on the Back on Track website, and I'm going to put that up in a second. But also, please give us a call. Go online, file a complaint with any company that we regulate. Next. So before we get to questions, I just wanted to go over a few student borrower resources. We have a dedicated student loan website, the one I was just talking about, for program resources. It's called Back on Track, and the link is right here. Once this is emailed you, you can click on it, but just in case, it is dfpi.ca.gov/backontrack. Also, please check out our YouTube channel for this recording and many other interesting webinars on a variety of financial topics, including our previous recordings of student loan webinars. That's youtube.com/CADFPI, and make sure to subscribe so you always know about new content that we post. Also, please consider subscribing to our Consumer Connection newsletter. It's continuous updates on all things student loans, as well as other important information and consumer alerts, upcoming events, and webinars that might interest you. Here's some other important links that you might find useful as well. Again, you'll receive a copy of these slides, so go ahead and you can just click on any links that you need. And of course, at the bottom is Celina's contact information. Feel free to please reach out to her with any student loan related questions, especially if you have something specific that you don't want to ask in front of everybody else. She can help you, even if it's something that we can't handle or can't do for you, she can point you in the right direction and get you to that place. So next, let's go ahead and take some questions. If you haven't already, please add your question to the Q&A feature. Okay, and I think that we've already answered some of these questions, Celina, but the first is, can PSLF applicants continue to submit their forms to receive credit for months that are in deferment while the litigation is underway?
Oh, good question. Yes, they can. And so these are two different programs, just to clarify. So PSLF and the Biden relief, which the litigation is taking place for, they're two separate programs, and PSLF applicants can continue certifying, and any months during the repayment pause where they're not paying are counting towards PSLF. So that's at this point about over 30 months of PSLF credit that borrowers are getting, where they haven't had to make payments, but they're still getting that credit. So it's very important that they certify. It has nothing to do with the litigation. PSLF is still moving forward.
Okay, great, thanks. And again, I think you might have brushed on this, but we always receive a lot of questions. What about Parent Plus loans? Do they qualify?
They do qualify, but like I think I mentioned this during the slide, they do have to consolidate into a direct loan. And when they do consolidate into a direct loan, their payment count does reset. So they do have to start at 0 months and then continue working for the 120 qualifying payments, or making 120 qualifying payments to be granted forgiveness.
Okay, and earlier in the webinar, you stated that the IDR is the best payment option under PSLF. Why is that?
Because there's only, it's either the IDR plan or the standard repayment. Under the standard repayment, a borrower is scheduled to be done in 10 months anyway. So that payment is scheduled to, is calculated at 10 years, which is the amount for the same amount for PSLF. So let's say a borrower was to be starting at 0, if they started paying under the standard repayment, they would be done with their loan, with their balance in 10 years anyway. So it's either that or the IDR, and IDR is going to base their payment on their income, not on the 10 years. So that's why the IDR, income-driven repayment plan, is the best one. In some cases where a borrower has a low balance amount and has a high income, IDR may not be the best one, but typically for borrowers, that's why we recommend that one.
Okay, thank you. And then someone mentioned that contacting MOHELA over the phone has been really difficult, and they've been placed on hold forever. They never answer. Can DFPI help them get through?
We can't help them get through on the phone, but one suggestion and one thing that I found from borrowers is the chat function works online. Also, if they are not able to get through and they want something in writing, what I would recommend is to file a complaint through us, and just to ask whether it's about PSLF, if they received the information, the application. When a borrower files a complaint through us, not only do we get notified about what's going on, we want to know what MOHELA is doing and not doing, but they have to respond within 15 days in writing, which is better for borrowers.
Okay, good to know. When will the Department of Education notify borrowers of debt forgiveness?
They will be notifying them as soon as the litigation is resolved. So the Supreme Court is scheduled to hear oral arguments the end of February. Depending on when that decision comes out, they can either say, we're going to move forward, or they can either allow it to go forward, and then Department of Education will just move forward with the applications. If they just completely block the program, then at that point, Department of Education will maybe have alternative options for borrowers, but it will be as soon as Supreme Court puts out the decision.
Okay. Let's see. Will the weighted average also be used for PSLF forms that have already been submitted?
Well, the weighted average will be for anybody who consolidated. So if they consolidated, so the waiver, if anyone consolidated previously to the waiver, they will get the full amount. And now moving forward, yes. So they will, if you consolidated after the waiver, it is my understanding they will use a weighted average from November 1st forward.
Okay, great. Will payment counts while in deferment under PSLF be at risk of being reset while the applicant is employed in public service?
Well, no, the only time when payments are reset is when a borrower, it has to do with consolidation. So if a borrower consolidates like a Parent Plus loan or a FEL loan into a direct loan and then applies, that's when the payment count is reset. So that's when we're talking about resetting, it has to do with consolidation, not with deferment. So if let's say a borrower applied at one point and then they worked for a few months and then went into deferment, and then they went back to work, that it wouldn't reset the count. They would just pick up where they left off.
Okay, great. For public service workers working 40 hours a week, so full-time, how are extra hours calculated in PSLF?
They are not. It's just 30 hours. If you work 30 hours or more, then you're considered full-time. So they don't take the additional hours and give you extra PSLF counts. It's just 30 hours.
Okay. Can you please give more details on the July 2023 changes to interest capitalizations? Will they stop in July of 2023, or are there caveats?
No, these guidelines or these changes will take place or start July 1st. So July 1st forward, then these changes will start.
Okay, great. Let's see, will borrowers who have borrower defense application granted but are not part of the sweet settlement get a refund of previous payments?
I believe under the terms they don't. So, but there are new guidelines. No, they won't. They won't. The refunds are only for those under the class action settlement.
Okay, great. Okay, this is kind of a long one. One-time payment count revision for eligible IDR borrowers. As part of this initiative, let's see, Department of Education will conduct a one-time revision of IDR qualifying payments for the William D. Ford Federal Direct Loan Program and federally managed Federal Family Education Loan, so the FEL program loans. Let's see. Okay, the original statute on the Biden administration rules indicated periods of deferment and forbearance. It did not specify a particular type of deferment or forbearance. Are you now saying you must fall under specific criteria?
For which one? I'm sorry.
Periods of deferment and forbearance, and this is under the Biden administration's.
Is it for the IDR adjustment?
I'm assuming, it doesn't say.
The only periods of deferment that aren't going to count are going to be in school deferment. And then forbearance, it has to be either the 12 months or the 36 months. But the only the deferment that they're not going to count is in school.
Okay. I see.
I hope that answers that question. Sorry.
I think so. Oh, I see. The above is that you said only counts under specific reasons. But again, I'm assuming that's for IDR.
So there is a link in the PowerPoint to the IDR adjustment, and there's all the information, and it gives specific, it gives all the information about what periods are going to count. So if I, just to clarify, or if I don't answer the question, they can also go ahead and click on that link, and that's directly from studentaid.gov that has more specific information. It's a whole, they have FAQs there as well.
Okay. Next, finding the PSLF form on the Department of Education's website is not easy to find. Can you please post or send the link for the PSLF form?
Okay, I can get that.
And I believe that's on the Back on Track website as well, the resource page.
Okay.
There should be a direct link.
Yeah, I keep a copy of that so I can put it on the.
Okay, well, I think that we can end a little bit early. I know this is a busy week for everyone. Again, if you have more questions, please feel free to email Celina, and that information is on the slides. Thank you so much for joining us. We hope you found this information helpful. Thank you so much to Celina for great information and updates and letting us know what we can do in the meantime while we're kind of in this holding pattern. Again, please subscribe to our newsletter so you don't miss any student loan updates or registration information for our next webinar. Thank you all and happy holidays and take care.
Thank you, everyone. Thank you for joining us. Happy New Year.